we're going to, I guess, jump into it from here. So this morning, we're speaking through really the sort of ins and outs of putting together claims around the shutdown. I'll be speaking with Claire Brennan. Claire's one of the senior lawyers in our team that really specialises around preparing and putting together and negotiating contracts, as well as the delivery of projects, in particular helping a lot of our clients, contractors and builders and principals, preparing meaningful claims and responses to claims. Good morning, Claire.
Hello, how are you going?
Yeah, good. And Claire's very fortunate. She's on the mid-north coast, so she's a bit insulated from what's in Sydney. I'm in Newcastle, so I'm experiencing a bit of the same. So I guess we wanted to open by saying, look, thoughts with everyone and everyone's businesses, particularly in Sydney. We know it's a really tough time where, some of our teams in lockdown and as well. So we're really with you, even if, we still have a little bit more freedom than you do. So look, I wanted to jump straight in, and I'm excited by this as being my first slide. No changes. And I mean, look, it would have been nice to see, a positive change, but in many respects, I'm just happy when I got up this morning, I didn't have to go through and find a new piece of legislation or a new order that conflicted with what the government had been saying. So I guess, things continue as per what we discussed yesterday morning. So that public health order that came to effect over the course of the weekend and rolled into your I'm sure very chaotic days yesterday is still stands as we put it yesterday. So I guess the immediate action we talked through again yesterday, around securing site, identifying and attending to all urgent work, identifying what you need to do that falls outside of the lockdown, notifying employees, contractors, subcontractors, making plans around the order and delivery of materials, securing materials and equipment, and putting in place communications and systems is still absolutely current and absolutely critical. And the big ticket one is still start working through your contracts and preparing your claims. So yesterday we did touch on the types of claims that, or the types of clauses, and you might be looking at to try and work out if you have a claim or what those claims might be. So those are going to include the COVID-19 clauses we talked through yesterday, EOT, programming clauses, variations, payment provisions, the changes in legislation provisions, suspension rights around scope reduction, side risk insurance, any related agreements, tripartite agreements, and some of the clauses associated with the same. But I guess I'm going to jump across and throw to Claire, and she's largely going to run through what we're talking through this morning. So I'll be a bit more in the background. You've heard enough of my voice over the last 2 days, and I'll be speaking on employment issues this afternoon. So thanks, Claire. Thanks for logging in, and thanks for preparing this for everyone this morning.
Thanks, Mike. I get right into it. Probably the first thing we need to address is why do you use notices? How can they be useful? And I guess the key points are they're useful to facilitate the accurate flow of information. They provide a formal method of record keeping, so you know what's been discussed, what's been decided in case it becomes a problem down the line. And they can be used to preserve your rights by keeping the door open for claims further down the road. So I think for all those reasons, they're really useful for avoiding or managing disputes, and particularly relevant at this time, of course. However, whilst they are really useful for that, you do run the risk of losing entitlements if they're not prepared correctly. You'll probably no doubt all know that contracts are really particular around this point, and there'll be a whole bunch of requirements that you have to include in your notice to make sure that it's valid, and they'll be spread throughout all the clauses, and they'll be different contract to contract. Even like as between two GC21s, you can't assume that the obligations for your notice will be the same.
I think that's been very much the case. Unfortunately, I know that we've got a mix of people working on here today. If you're a home builder and working under, say, the HIA, MBA or ABIC standard suites, there might be a degree of consistency, but anyone that's working across the Australian standards, GC or bespoke contracts, I mean, the breadth of change we see from contract to contract is quite extraordinary, isn't it, Claire?
It is, yeah. And while there are some kind of like common things that you have to include that you see, there is such a variety of all sorts of things you might need for your particular notice. And so you just can't make the assumption. You can't really use, templates from a previous project, unfortunately. And that's because omitting some small detail can, as you said yesterday, Mike, cause you problems with claims. And can sometimes, depending on the wording, not only disentitle you from the claim that you're trying to make, but from all connected claims. Sometimes we've seen that wording that it'll wipe out claims associated with the one that you're making. So just got to be careful.
I mean, it's from our perspective, it is frustrating. It's sometimes lazy drafting, or if I can frame it as tricky drafting for the sake of trying to create disentitlement provisions. But those are what exist in a lot of contracts. We need to be pretty clear that you've got to go through contracts, like Claire said, on a case-by-case basis, because I was looking at one just yesterday, and there was a clause 47 hidden in the back that had some weird disentitlement provisions if you didn't include additional information to what was usually included with the time, and variation clauses. So I don't think that's good drafting. I don't think that's good practice, but if we're being honest, that does exist in some contracts out there. Not that have been prepared by Claire and I, but certainly ones that we see from time to time.
No, we've never drafted anything like that. You're right. It does seem to be more common to try to include those sort of tricky drafting provisions that'll make it difficult to claim. So this slide is really about trying to avoid that happening to you, and it is simple to do. It's just time consuming. As Aaron said yesterday in our presentation, you've just got to read the contract really closely, start early. Because often before you even get to including the facts of your particular claim, just putting the template together, and collecting all of these requirements from, clause 1 to clause 47 can be time consuming.
And I think now's the trigger for that, if it hasn't been done already. Is that fair, Claire? I mean, often we recommend trying to put these claims together in a map around how to make claims at the start of the contract, because that's, before the chaos really hits, I suppose, for a lot of people. But if it hasn't been done yet, with what happened over the weekend, now's that moment in time to do that deep dive into the contract and work out what pathways might be there and what those claims need to look like.
Yeah, absolutely. Definitely now, if you haven't already, get into it. That third point there is really important. As you're doing this process, just be aware of how the information has to be given. It's usually not enough just to state your position and say that your delay, say it is on the critical path. Often you'll need to go a bit further and attach some information, or demonstrate or explain.
Can you take me through that in a bit more detail, Claire? It feels like, I suppose, and we've talked about this internally as lawyers, it feels like sometimes, the way the words that are used are kind of like an essay question when you're in year 5 or 6, where you're asked, the word identify means something very different to explain, which then means something very different to demonstrate.
Yeah, absolutely. I think that's a really good example. I remember doing that in year 5 or 6, and having that drilled into you to really read the question carefully. So sometimes it'll be, justify or explain why the delay, is causing you to be on the critical path, and attach your program and sort of set it out in that level of detail. And one thing that I think is really useful in doing that, if you're not sure if you've given enough information, and we'll come to this later, include that piece of information under a heading that says, something as explicit as why the delay is on the critical path, so that at least you're sort of flagging to the other party, this is meant to satisfy this requirement, so it's clear what you're trying to do.
It's a really useful internal tool doing that as well, particularly when you've got a lot of claims and a lot of projects on the go. If you're a contract administrator, or you're running the contracts team, or you're just the person, unfortunately, with the pile of contracts on your desk, building claims out in a way where you're asking questions like that also makes it easier for your team, including people on the ground that might be rushing into these and not turning their mind to it as fully as you'd like. Having them framed like that means that people are answering a specific question, which can then be passed through to the passed up the line. And speaking to project managers and people that are working as superintendents and principals reps, they might not always like it, but they do appreciate it, if I can frame it that way, because at least it explains, it gives the level of detail that helps them understand how you're looking to satisfy the requirements.
Yeah, it really speeds the process up, and avoids the back and forth that you come to if your notice is a bit ambiguous. Um,
You'll touch on this later, Claire, but this is obviously, we talk with clients a lot about the the program can be your best friend or your worst enemy, but certainly when you're putting these claims in, being able to show that change on a current program is quite wonderful in a lot of respects.
Absolutely. And I think the other thing just to say is, as a general rule, if you're unsure, put in more information than not in your notices.
Yeah, I agree.
So the next couple of slides are really just kind of walking through the types of clauses you definitely need to check, and what kind of things to keep an eye out for. So the first one is that the general overall time bar on claims. Usually there'll be something in the contract saying, that there's a time bar for all claims, and in AS it's usually around clause 40. Have a close read of that. Like, as you can see in the example of the GC21 on that slide, when that time period actually kicks off can vary. So in that clause, it's the later of the start of the event giving rise to the claim and when the contractor should have become aware. So not even just when you did become aware, but when you should have. So if you think in your particular circumstance for the claim you're putting together that's ambiguous, try to address it in your notice, just to head off a response from the other party, and just to make it all really clear.
Yeah, I mean, a good way to do that is just simply saying we could not have been aware of this delay earlier than this date because, and you're going to have that information in a better form than anyone else is going to.
Yeah, that's right.
Yeah. I think one of the things about this shutdown, we touched on it briefly yesterday. It's hard to have guessed that the shutdown was going to happen before it did happen. So, the critical date really falls on the Saturday, or, the following business day, depending on how your contract is framed. But we had no true inkling or true knowledge, I suppose, that the construction industry was going to be shut down, nor any sort of precedent examples. Melbourne hadn't behaved the same way. Melbourne's probably the easiest reference point because they've had, unfortunately, the most and some of the hardest lockdowns. So in terms of that critical date, where, unless you think otherwise, Claire, I think we really are working from Saturday, or at the latest, if it's the next business day, Monday.
Yeah, no, I would agree. And I think if you can, and if you've got the time, work from the earlier of the two possible dates, or, just to be safe. Probably the next key thing we check is the general notices clause. And this is the one that tells you how to give notices, whether it's by post or hand or email. We're seeing fax less and less, thankfully. And just, have a close read of this one. Usually it'll also say, depending on the method of delivery you're using, when you can assume that it has been received by the other party. And that becomes important if you're, God forbid, submitting something close to close of business on the day it's due. Have a look at the definition of business day. That'll vary jurisdiction to jurisdiction and contract to contract, so be careful of that. And watch out with this one for how it could be modified by another clause. So it might say here, yes, you can give notices by email, but check the clause that relates to your notice. Like if it's a delay notice, does the delay clause say it has to be by registered post or by hand or something like that?
We do see those more often than we'd like. Claire and I had one on a commercial contract last year, and it ended up quite a protracted negotiation on the principal refusing to accept certain notices by email, despite wanting everything else by email, which is extraordinarily frustrating if you're the contractor. I think that that project's now completed, fortunately, but in the context of what the current lockdown is, there may be some real difficulties if you're not allowed to do it by email, for example, or using Aconex or something similar. Logistically, how are you going to get that notice there? It might be something you really need to consider.
Definitely. And I've just thrown in a point there as something to think about. What happens if you send it by email and you get an out of office reply? or you think, for whatever reason, it might not have been received by the other party. And this is a little bit complex. It'll turn on the terms of your contract, some related legislation, and potentially the conduct of the parties up to this time. But I think, Mike, you'll probably agree, just as a first point, like if you're unsure that it's been received, just go out of your way to make sure, give them a call, even drop around and hand it over, in person, just to be absolutely sure your claim is going to go in.
Yeah. I mean, in worst case scenario, what's really critical is using, if it says you can serve it by email, using the email prescribed by the contract. Send it to the usual person you contact. But if the contract, for example, of Part A, I'm just using an Australian Standard Suite as an example, has a listed email address for service of notices, make sure you use that. Even if you get the out of office or bounce back or some other problem, then you can at least potentially put your hands in there and go, look, I've complied strictly with the contract. The fact that their inbox was full is out of my control. I still serve that notice. And there's been some case law around that. I agree with Claire though, like that's when you're doing it at the 11th hour. If something like that does happen and you need to work out another way to get there, at least you have time. Showing my age a bit more here, I recall, particularly when email wasn't a prescribed method of service, having to deal with people turning off their fax machines, particularly in the context of security of payment, and having to personally rush and stuff things under the door before 5 o'clock. So, there is poor behaviour from time to time, and we're hoping that that's not going to be the case. But obviously, the earlier you get your notice in, the less margin for those kind of errors popping up, and really make sure that you're using the emails prescribed by the contract. One thing I will comment on this as well, you might be working across a few agreements, particularly if you're the head contractor. There might be a tripartite agreement as well. We do see from time to time, not only the notices needing to be served on the financier through the tripartite, but a separate notice for a separate address or email address in most instances for the principal under that tripartite agreement, because it's going to say the CFO, for example, instead of a project team. Make sure that you try and capture all the service entities across the various documents. I know that's adding a layer of confusion, but just one that we do see from time to time.
Yeah, that's a very good point. That's when the Part A annexure, if it's an AS, becomes really important to look closely at.
Yeah. I'll also comment, we're working through, we'll try and get through it as quickly as possible. We've only got we're halfway there already. If people do have questions, throw things in the Q&A. I'll monitor it in the background. And if there is anything you'd like answered, we'll do our best job to do so. And we're obviously going to circulate this in the slides after all this is done and we've collated all the information. But yeah, if there's any questions, let us know. And if we can't answer it now, we're also trying to put together some Q&A documents for people as well.
So the next place to check is, of course, the primary clause that your notice relates to. This one will usually stretch over a couple of subclauses and have a whole heap of things you've got to do, whether it's attach a program or include a description of the steps you've taken to mitigate whatever, if it's a delay, to mitigate the delay. Again, be careful of the evidence thresholds, that idea of, do you have to explain something? Do you have to demonstrate something? If it's a latent condition, do you have to explain why it wouldn't have reasonably been anticipated, that kind of thing. As Mike said yesterday, keep an eye out for the ongoing notice requirements. It might be, if the delay is ongoing, you've got to give a notice every 5 to 10 business days. And if you miss one of those, it's just as important and critical as the first notice. So use your calendar reminders to make sure that all gets done.
Yeah, I mean, having auto-sent emails, particularly when it's a delay like this that isn't changing, or the substance of it isn't changing, is quite useful. We often have, when we're helping contractors, reminders set up in ours to send them the draft email for them to then, just immediately press forward on, because you can set it up to automatically send those emails. So you can try and make your life easier with a little bit of tech as well.
Definitely. And the other thing that's useful to check for in the clause and also in the annexure or commercial schedule, whatever your contract might be, is there a time for the other party's response? And it can be useful just to put a line in at the end of your notice saying, per clause blah, you're required to respond within 14 days, just to keep things moving. The last point is really important. Check the definitions that are used in this clause. They often contain obligations that you've got to satisfy in your notice, but because they're hidden away in the definitions, you might not sort of think of them. But terms like qualifying cause of delay or compensable cause often have those types of obligations. That example there for force majeure, for example, says, it includes fire, flood, natural disaster, etc. But then it has those trailing words saying, provided that the event couldn't have been reasonably anticipated. So you've got to think, in this circumstance, is that going to be a problem for me? And should I sort of set out some evidence as to why that's not going to be a problem?
I think, going back to what we talked about here, we're hoping this information is generally useful and will be useful on other projects. But in the context of this, the Sydney COVID shutdown, I think it's pretty easy to explain, or at least to mount the initial argument why you couldn't have reasonably anticipated it, because it wasn't announced. It hasn't been happening in Australia. Examples overseas, I don't think, are entirely relevant to what we're doing here. So you can sort of explain your work within the context of what's gone before, and a construction shutdown had not happened, and construction work had been considered essential up until a few days ago. Claire, we've got a question coming through. I might read it out and we can answer it live if that's okay. So under a standard unamended Australian standard, if we have achieved PC and have additional variation works instructed on minor works agreed to be completed after PC, which we have agreed dates to do so, do I still need to send notices of delay, EOTs, etc.? My view, I'll run through mine first, and we haven't talked through these things, so if Claire's got a different one, we'll debate live on air, I suppose. But look, my answer is yes. Like, work within the parameters that are given to you by the contract, and if that's built the communication protocol that has been developed between the parties, and you're still working within that contractual framework, provide notices as if as per what's given to you by the contract. It may not be necessarily needed. I mean, there can be some arguments around whether there's a collateral agreement and a whole bunch of other things, but for ease of reference, my usual practice would be to work within those timeframes and parameters as provided to you under that existing contract. Claire, did you have a different view or further thoughts?
No, sadly, I completely agree. There won't be much of a debate about this, but I think unless there's been a really clear change to the protocol that's been used so fast, stick with it, because it'll no doubt be what the other party's expecting, in going forward.
Yeah, look, we've had these ones where we've had to argue there's a collateral contract or something that's followed on after the event and different protocols apply, but that is more difficult. Like, if you've got a framework that's easy to work from, and particularly if you've got an unamended AS 4000 one, great. We don't see as many of those as we used to, but it's a reasonably generous framework to be working within. And if the context was even a heavily amended nasty contract, we'd be saying much the same thing. Like, use best practice where you can, and that's using the existing tools that have been provided or communication protocol that's built out by your contract. I'll jump across, Claire.
Yep, thank you. Next, the key thing is think about the pricing. If your notice is about a change to the contract sum or other pricing change, delay costs or something like that, usually there'll be a clause that governs the method for that change. So make sure you follow that, or if you're not following it, give some explanation as to why. And again, check the definitions. Like, if you're claiming delay costs, does the definition of delay costs include qualifiers like they have to be reasonably and directly incurred or something like that? And if so, attach evidence and explain why you think they are reasonably and directly incurred.
Again, with all of these ones, it's a matter of doing that map at the outset is really important. Aaron and I emphasised, the COVID-19 clauses or pandemic clauses or whatever that are starting to appear in contracts. But sometimes there's obligations that run across multiple clauses, so you don't want to deal with the cost component of one and leave your cap unfeathered, so to speak, in relation to another. So Claire and I have been looking at a few of those in the last day already. Claim under anything you're entitled to make a claim under. It's the safest way. I'm not saying you you fling some mud at a wall and hope it sticks, but if there's multiple avenues, use them, because there might be a more sensible path or one that's more agreeable for both parties.
That's a really good point. We're whizzing through this. Probably only a couple of slides left. Other things to think about, I think, on the next slide, Mike.
Yeah. We've just had a question come in. I might answer those as we go along, if that's okay, Claire. Just we do, and everyone, we want to try and get through this quickly because we know people are busy. So if things follow up that we haven't dealt with or you want to address, please just message Claire or I or our team directly. But so Sam Fogarty's asked, what mitigation measures could be implemented to reasonably mitigate the effects of the industry shutdown? Typical measures include resequencing programming tasks, subcontracting portions of scope, increase in resources cannot be justified. It is a really good question, and the mitigation, it's going to be project by project. You're going to know that your project's better than we do, and you have project delivery teams that are more sophisticated in most respects around project delivery than we are. We're people that get our heads into the contract, I guess. It may be the case that there's, beyond doing those things I talked about right at the outset around making sure that you've tried to get materials delivered elsewhere or stored securely off-site, or really taking those steps to prevent deterioration of the work. There might not be much you can do, and explaining, you might have to explain that in the context of the current orders that are in effect, beyond making sure damage doesn't happen, or trying to get things ordered but still secured elsewhere. There might be very few mitigation things that you might be able to do at the moment. It's a really good question, because basically they've said you shut down, you make sure things don't fall apart, and that's about or get damaged by someone else, and that's about the extent of what you can do. So unfortunately, it might be minimal mitigation. Playing with your program and working out how you can potentially resequence, considering, we didn't talk about this yesterday, whether you want to make a request to accelerate coming out of this, because it might take a few weeks to get moved, and then you can sort of allocate more resources towards it down the track. That might be something you consider. But it's a good question, because it's pretty tough, because with a full shutdown, mitigation might be minimal. Claire, did you have any thoughts?
No, I agree. This is a bit of an unusual one. Normally, there's heaps of things you can show you're doing to keep things moving in the background, or mitigating the effects of the delay. But in this situation, it is a bit different, and maybe it is just a matter of making sure you're ready to go when you can go again, and just explaining, in a 1 or 2 line in your notice that there's not that you're doing everything you can, but because of the current orders, you can't do much more.
Okay. Another question. Talking specifically about this COVID lockdown, can we claim the cost incurred due to non-critical trades? For example, if the crane was planned to be dismantled tomorrow on site, but cannot be done until 2 weeks, while it does not have an impact on the critical path, it does result in, it is additional cost to the contractor. What avenues do we have? It's going to be a contract-specific pathway, for better or for worse. And I do hope you're in a contract that might give you entitlement to some cost for this type of shutdown. A lot of contracts don't, to be frank. A lot of contracts will give you the time around this kind of shutdown. Some won't give you either, which is pretty yucky, and you might have to be arguing some other estoppel and extra contractual remedies. But it's going to be a contract-specific entitlement. And if it doesn't exist under your contract, it might be quite difficult. Claire, did you have again, we might get something we debate, but do you have any thoughts?
No, sadly, we're on the same page. I think that is a bit of a tough one, particularly because the reason for that circumstance wasn't caused by the other party. It's rare to see an ability to claim costs for that, but it'll turn on the contract.
Yeah, HIA MBA standard forms, you probably would get some cost for that, or be able to find an avenue for that. A lot of the amended AS Australian standard documents, or GC or bespoke, those pathways are a lot more difficult. So if you need any advice around that, please reach out afterwards. But it is going to, that entitlement is going to exist solely through the contract, and you'll be looking at some of the clauses we spoke about yesterday. So your COVID clause, your EOT and delay damages clauses, changes in legislative provisions might give a bit of an avenue for you, and then just working through the document to see if there's any pathways there. Claire, were there any other potential clause areas that you thought that you can think of off the top of your head?
I think those are the main ones. Probably any other ones will just be sort of left of center and dependent on the contract. But those ones you've hit, I think, are the key ones to check first.
Yeah. Okay, great. So other things to check, Claire?
Other things to check is that, first of all, the commercial attachment, usually Part A in an AS contract. Often there'll be something there saying the principal has to respond within 14 days. Again, that's just useful to note to keep things moving. Or it might say that the contractor has to give reasonable notice of when it needs instructions or directions. So keep that in mind. This is, as we've mentioned before, double check the addresses and addressees. Do you need to CC someone that you hadn't anticipated? Make sure all that's correct. It's also useful to check through the commercial and technical schedules for any kind of semi-legal things that might be hiding there, although that's not all that common.
The other thing, I suppose, with the addresses and addressees, double check there hasn't been a notice change in that throughout the life of a contract, particularly if one of the original project managers has left, for example, or if the project's been going for a long time. You sometimes see those changes done softly over emails, and you want to make sure you try and capture those as best you can too.
That's a good point. A lot of these things are just simple to do, but just thinking of them and making sure you get them done so that your claim is valid is important.
Yep.
The final point there is just a kind of backstop. As we said earlier, it's best to read the contract in full if you've got the time. But if not, this can be a useful tool to control find these time references just in case they pick up something you might have missed, particularly those like immediately or prior to. You might just be looking or focusing on business days, but that helps you pick up things you might not have noticed.
And it's not unusual. Again, I think it's poor drafting, so I'll put that out there before I start talking, to have date, days, business days, and if you're especially lucky in working days, which has a different definition again, hidden in the same contract. I put that down sometimes to lazy drafting because it's been, people have been using the same document, updated and added new terms as time's gone on, but sometimes it's intentionally designed to be tricky. So, the one that I find extraordinarily frustrating and a bit cheap is when you're allowed to do things mostly on 5 business days, but there's the occasional one on 5 days. And that's really important when in the context of this COVID notice, because that 5 days tick in from Saturday is a lot shorter period than 5 days tick in from Monday.
Yeah, absolutely. Keep an eye out for the reference to working days. That's one that can be a bit tricky if business days is defined and working days defined, and they're different.
Yeah.
Sorry,
we'll finish this one, and then Tony's got a question that we'll run through as well.
Yeah, go for it now.
Okay, so Tony's asked, with the MBA cost plus residential cost plus contract, can we claim brackets on charge the measures primary labour needed to be taken to secure the site? My preliminary answer, and again, we've had our little disclaimer at the start, this isn't meant to be legal advice, it's trying to give you helpful tools, is there are avenues under the MBA residential cost plus to claim those things for changes in legislative requirements. So the MBA suite of contracts is the most contractor builder friendly suite we've got in Australia by a long stretch, and it does have some provisions that will allow for some of that to be on charge to the person you're working for. Again, you're probably looking around the time provisions and what are, what's defined as compensable causes under the Australian standard suite, but there are some provisions in that might allow for at least some of those costs to be passed on. Sorry, Claire, next slide for you.
Yes, thanks. This one is really just common sense, but useful to turn your mind to. Form and content, making it readable for the other party, just streamlines things, speeds things up. There's less back and forth as to what, clarifying what you've tried to say. Have a think about the way you want to do that. It's up to you. We've seen all sorts of things using tables or using headings. Headings, I think, are really useful, as I mentioned earlier, just to flag to the other party, the information under this heading is intended to satisfy this particular clause. So if your notice requirement is that you explain why a latent condition couldn't have been reasonably anticipated, then have a heading that says why the latent condition couldn't have been reasonably anticipated. It's just at the minimum supports that your notice is valid, even if they disagree with what you've put under that heading. at least you could point to that and say, look, I've ticked all the boxes. The notice itself is in and valid.
I think people also, it's important not to get caught up in the formality of language too much. One of the things is the contract may have some requirements to identify, like Claire said, the contract, the project, the parties, the date, and the clause under which you're making the claim. But if you want to use, if it's easier for your team to use more parochial language in describing what they're doing, use the language that they're comfortable with. You want to get the notice in. You don't want people to feel like they have to be using sophisticated terminology the whole time to explain it. You're better off getting the notice in with the essential elements described in a way that your team is comfortable describing it. And like Claire said, breaking it down into those elements that are, Q&A approach it can be really sensible, because we've found when we've asked people, and I guess we're often dealing with it when it's a bit hairier, when things are moving towards a dispute, but when we've asked someone to sort of write out a notice, sometimes people are pulling out their hair. But then if we sit there and go, well, what happened? What caused the delay? What do you have to do? They can talk about it like that. And getting that language down in a notice is fine. It doesn't have to be perfect. It just needs to explain it. And if using people's everyday words is the best way for them to do it, absolutely. We're very comfortable with that approach as lawyers.
I think that's fair. I guess you've got to do what works for you. But these are, I guess, just some tools to, if you've got the time right after you've signed the contract to put these together, these are all the things ideally you'd have in there. I guess, subject to your points there, Michael, about just getting it in and making sure it's something that you can do and your team's comfortable with doing. It can be useful to put in clause references, your dates of events, those kinds of things.
Oh, absolutely. I think that can be really helpful. Sorry, I was talking more about the flow of the language rather than the essential elements, Claire. I probably overstepped a little bit.
Absolutely. Yeah, no, I'm with you on that point completely. A couple of other things to think about. If you're incorporating terms from the agreement itself, sometimes people will say, defined terms have the same meaning in this notice as in the contract. Just be a bit cautious, particularly around terms like business day. If you're capitalizing that, are you meaning it as defined in the contract, or do you have a more colloquial meaning in mind? Don't forget to attach all the stuff you need to attach. That's always something that's very easy to do. And make sure you date the notice itself.
With the attachments, just modern problems that start to arise. If, for example, all the attachments are sent by way of a Dropbox link or similar, make sure or test it out to make sure that that Dropbox link is live and accessible. So we've had it in the past where people have raised after the date saying, no, you didn't serve us with this because the Dropbox link didn't work. So make sure you've done the testing to. If you are sharing it through a bit of an unusual way, to make sure that they are received.
That's a really good point. That's reminded me, actually, sometimes you also see a requirement for notices to be, they can be delivered by email, but they have to be in the PDF attached to the email. It can't just be editable sort of wording in the email body. So that's another thing to keep an eye out for. And the last point there is just, if you're comfortable, it's often useful to use the party names, rather than saying, to the other party, you said X on blah day. That can sometimes come across as a bit aggressive, and sometimes that's not so useful, and it's better to use the objective language.
Yeah, no, I agree. We're probably more trained in the habit of referring to people as principal or contractor, but it does dehumanize is probably the wrong word, but it's that's a big part of it. If I'm saying, oh, Bob told me I can do this, then Bob gets worked up and says that's not what I meant, and suddenly you're arguing semantics rather than arguing the substantive issue. Using that kind of language can be really helpful in terms of making it more objective. Dehumanize was the wrong word.
Maybe, yeah. More objective and just take the heat out of a notice if it's sort of a bit more distanced in that way. That's more just something to think about. I guess in terms of closing comments, just again, attention to detail in this task is important. It's really easy to do. It's just time consuming, and you've got to sit down and really carefully read the contract. Again, I'd highlight those key words about how information has to be provided. And yeah, again, the time issue, just, you don't want to be doing this at, 4 o'clock on the day it's due.
Absolutely. If there's any more questions, now's the time to throw them out. This afternoon, we'll be looking at the employment law issues. So Mary-Ann Wen, who's one of our lawyers that specialises in employment, will be leading that. I'll be involved because unfortunately, Jacqueline Fenby, who's our employment director, has lost her voice today. So we hope she feels better, but I'll be in supporting Mary-Ann as she runs through that this afternoon. We are going to continue to run webinars over the course of the week, and we're trying to cap off on the critical issues that are getting put to us as we go along. So thank you for doing the claims today, Claire. So employment's this afternoon. Tomorrow morning, we'll be working through payment, and that'll be including talking about security of payment and what options people might have to get paid, because we're very conscious with the lockdown continuing till at least at this stage the end of the month, or the 30th, which is close enough to the end of the month. How people get paid might become a bit more precarious, showing what works are being done, people trying to rely on provisions of the contract to undo entitlements to be paid. For example, some force majeure contracts include provisions that if a force majeure event happens, all obligations, including payment, are suspended. So we're going to talk through that a bit more tomorrow. That's going to be Hamish Geddes, one of our directors, with Matt Bryan, a very senior lawyer that specialises particularly around security of payment. And then in the afternoon, we will be speaking through insurance at a more global level, a more detailed level than how we approached it globally yesterday. So that'll be Aaron Bolton again, and he'll be joined by Jonathan Frost from Bellrock Broking, who has kindly offered to help support us on that and give a bit of a broker's perspective on what people should be looking at in their insurance provision. So we're going to be particularly touching on business interruption and what those policies might look like, but also the common policies you're going to have as a construction business and on construction projects. And then to close out most of the week, we're going to be looking at director duties and then insolvency on Thursday. Again, we appreciate this is putting a lot of pressure on some businesses, so we're getting Dan Mills, Director of Business Advisory, William Buck, speaking with our team on Thursday morning around directors' duties, looking at your financials and what you should be doing there. And then in the afternoon, we're going to have Chad Rapsey, who's a senior restructuring advisor, speaking with Matt Bryan around safe harbour provisions and what to do if your business is in a bit of trouble. People should be really proactive about that. I'm just checking, I can't see any more questions popping up. So we're going to, a recording has been done of this. We are going to share it. We will be tweaking. We're building these out live. So I apologise. Claire, you've been wonderful today. I apologise if I've been a bit messy. But I guess we're going to be building these day to day, because that way if something changes overnight or something changes really in 13 minutes from now with the latest announcement, we can cover those in the afternoon and the subsequent morning sessions. So we're trying to make it as current as possible for everyone. We want it to be useful. We want it to help you directly. But obviously, if you need to seek specific legal advice, please feel like you can reach out to us. Our details are below. If you can't get onto Claire and I, we're usually pretty available. Our office number's below, and we've got our team of lawyers available to help. So thank you, everyone. Thank you for coming along today. And again, we hope you're all safe and well. And we're wishing you the best of luck with the business side of things too. Thanks, Claire.
Thanks, Mark.